Welcome to being incarnated on planet Earth. You are now gifted with the supernatural abilities because of our planet passing through a sector of the universe that activates God DNA within every man, woman, child. You are the new keeper of the flames of love. You are the keepers of supernatural powers when you invoke I am. And you are the gatekeeper of miracles every day and every way. I salute you in the spirit of Ubuntu.
Family, I am here with a magical moment of young musicians. And this is Kim, Sister Kim, and she has a message about investing into the future musicians of our community. Sister Kim, tell us what you got here.
Hi everyone, Kim, proud parent of children at the Big Apple Leadership Academy for the Arts. We teach HBCU high-stepping marching band to our kids from age 5 and up. It is a free after-school program, tuitionless, and it's open to all. Our kids are amazing. If you can, jump on our website. We're looking for support, donations. Our kids need new instruments so that they can high step on. Our website is www.balaa.org, BALAA.org. And I appreciate the time. Thank you. Thank you so much.
And so family, listen up close. We're talking about investing in the artists of tomorrow. By investing in them, if you have a little expendable change to invest in the youth, the genius, this is the opportunity. And in this description on this video will be the details of sending your donation to PayPal or Zelle or Cash App.
Yes.
Right?
Yes.
Okay. So thank you for your support.
Out a call to the warrior in you, to the healer in you, the king, the queen, the magician, the lover in you. Every single day, we are called to walk in our purpose. Answer the call. Lay down your burden and anything that holds you back and take your rightful place. The battle is everywhere. It's right in your face. Let's go.
Crystals and pyramids. Success is your destiny. Yes. Love, wisdom, power. Remember always who you are. Yes. Yes. I am love, wisdom, power. Yes. Yes.
Peace, everyone. Welcome. Welcome to Moorish Monday with Abdullah Il Talib Mosi Bey on Magnets, Crystals, Pyramid, YouTube. Special guest for the night is Brother King Al Bay. Will be joining us. Across the screen, today's topic is principles of contracts, looking for the principles in a contract with King Al Bay. Across the screen is my website, mooresandmasonry.org. To get my books, Moors and Masonry Part 1, Moors and Masonry Part 2, How Her Venus and Moon Rule, Etymology and Vocabulary, Etymology and Vocabulary Supplementary 1. Go to mooresandmasonry.org. Brother Israel, give King Al Bay a call. I just spoke to him 9 minutes ago. He said he would be, ready. His phone was charging. He will be ready. Just give him a call.
All right.
So we can, because I know he don't have his time is short for the night. So once again, today's topic is principles of contract. We're gonna have you put that on the screen. Before you had the flyer for the Midwest. So this is a very interesting topic for the night. There's the upcoming course that'll begin on May 10th. And the contract and trust legal safeguards course.
He said he's about to come on, brother.
All right, thank you.
All right.
Trust and contract and trust and legal safeguards course coming your way soon on May 10th. The course is $299 for the course. Brother Israel, you'll have the I guess we could put I'll post the link on my Facebook page. Oh yeah, we have here, just go back to that screen so he gets on the Moorish Midwest Educational Network.
Mm-hmm.
You have the Israel Bay 859-979-0049 for contact him. My number is 215-300-5471. Amanda Siegel is the administrative assistant. We'll also have our email addresses below our numbers. Facilitating study groups in 10 major cities. The value of proper education, a major help and resource for our people. We have King on now. All right. The 10 Lexington, Louisville, Cincinnati, Columbus, Cleveland, Pittsburgh, Detroit, Indianapolis, St. Louis, Chicago. We had the first live educational session on March 5th, Wednesday. So every first and third Wednesday of the month. So 7 p.m. to 9 p.m. Eastern Standard Time. So is he coming on now?
Yeah, he should be. He told me to send him the link, so yeah, we should be.
He has the link. The stream. Send him the link again. Just send it again. No problem. Send it again. Yeah, I sent it a few hours ago. All right. So yeah, we get. So once again, we have Brother King Al Bay. Those who are just joining us. Today's topic is principles of contract. A look into the principles of contract. Looking into principles of a contract. So King should be joining us any moment. Once again, my website, mooresandmasonry.org. Strolling across the screen. You see here the flyer, the Moorish Midwest Educational Network study sessions every first and third Wednesday of the month, 7 p.m. to 9 p.m. Eastern Standard Time, live on Zoom. And so we had our first one on last week of Wednesday. Yeah. We'll have also the Telegram, the Moorish Midwest Educational Network Telegram group page. All right, so the Moorish investigator and research, Moorish investigator and research. So we have King with us. We have here the Moorish Investigative Research Committee educational lessons on the Moroccan Post Media YouTube page. We free recorded lessons. Moroccan Post School of Government International Law, Terrence Bey, Shemal Malachi Bey, and Abdullah El Telemosi Bey. Moorish Union of Sovereign Tribes, King Al Bey. Session 1, the basics of criminal investigation, the meaning of evidence, finding of facts, and conclusion of law. Session 2, introduction to the application of law and evidentiary standards, part 1. Session 3, introduction to the application of law, evidentiary standards, part 2. Session 4, using legal principles to draft motions and pleadings, part 1. Session 5, jurisprudence, philosophy of law, and legal principles as the foundation to run government and to handle legal cases. Session 6, using legal principles to draft motions and pleadings, part 2. Session 7, the use of affidavits, notary processes, and notary presentment. All right, Brother King, once again, we have the topic is the principles of contract, looking into the principles of a contract. All right, Brother King, we go right to it.
Okay. All right. So,
yeah, because I know your time is short for the night, so we're gonna get right to it.
Okay, Brother Israel, you want to read this?
Yeah. All right. So the 4 supplemental principles in commercial transactions often refer to widely recognized principles that complement the foundational concepts of commercial law. These principles ensure fairness, predictability, and efficiency in business dealings. They are: number 1, good faith. Parties to a transaction are expected to act honestly and fairly in their dealings. Good faith is a fundamental requirement in contracts and commercial interactions to prevent deceptive practices.
Okay. So, remember, when we start talking about good faith, and one of the elements that we need to always remember too, that we operate in good faith and in clean hands. What do that mean? That you're not doing something deceptive, that you're being honest about what you're doing. When we're dealing in contract law, every contract needs to be performed in good faith. What do that mean, right? That means you're exercising something with somebody else. You gave them all the proper information to be able to decide if they wanted to contract or not. Go on to 2.
Number 2, freedom of contract. Parties have the autonomy to structure their agreements as they see fit, provided they adhere to the law. This principle emphasizes that the terms and conditions of a contract are generally determined by mutual consent.
So, this is a fundamental right. I want y'all to understand this. When we talk about fundamental principles and fundamental rights, we're talking about personal rights of an individual and states. The state and you are on equal footing. What do I mean by equal footing? You guys have the right to contract any way that you see fit. So when you go into the public domain, right, into a public jurisdiction, they control it because they got legislation. When you got a corporation, an LLC and stuff like that, right, that is dictated by the substantive language, the language that created such entity. And it's required to do certain things and reporting requirements and taxes to the state. So you got to understand the condition that you're in under contract. These is contractual conditions. Now, when we talk about trust law, when we're dealing in private rights, right? When we talk about a common law trust, right? Now we're dealing with principles of common law under fundamental rights to give you the right, constitutional right because the Constitution is going to protect your personal right, to contract. So a lot of y'all think you need an EIN to create a trust. No, you can have a private trust that then contract with a trust that has an EIN. And since it's the principle, it based on the property that is relinquished, it controls how the entity, what it can do with the property, how it can use the property, who can use the property, how the property can be used. All of these things can be identified in the contract when we're talking about exercising these rights to contract. So a lot of y'all talking about, I got a 498, this, that, and the third. But yet, you still don't have a private trust that contract with that trust, and then you don't know the contractual language that's necessary to safeguard your rights. Okay. Let's go to the next one.
Number 3, pacta sunt servanda, Latin for agreements must be kept. This principle holds that contracts and promises that are legally binding should be honored and performed as agreed.
So, when we're talking about staying in honor, right, of all costs, right, when we talk about staying in honor, a lot of people don't understand what they mean by staying in honor of all costs. Staying in honor means that you looked at the contract and you're based on the 4 corner rules that you are in honor, right? But the contract can have errors, omissions, and mistakes. And if you don't know how to identify those errors, omissions, and mistakes, and if there's certain language that cause you not to be able to perform, that's what we call an impossibility. Based on the vagueness and the utilization of the words on the contract, right? The contract can have vagueness in which certain components of that contract is too vague for you to perform. That doesn't mean that the other parts of the contract cannot be enforced, but certain things within that contract that can now, you can say there's an error, it's too vague, or you can argue that legally based on what you understand about the contract, and now you can say it's impossible for me to perform that as a defense, a legal defense. I can go into other aspects, but I only got an hour. Okay, part 4.
Number 4, reasonableness and fair dealing. In commercial transactions, actions, and decisions should align with what is reasonable. In commercial transactions, actions, and decisions should align with what a reasonable person would consider fair under the circumstances. This principle ensures equitable outcomes and prevents oppressive practices.
So, okay, so when so a lot of you guys need to understand when you go into a market, right? A particular market, they have pretty much certain rates on certain things. This is the market rate, right? So now when you identify with that particular market with a particular product or whatever, now you can understand the market rate. If something is outside the norm of the market rate, right, it can be 20 times the amount. And if it's a common product and they're selling it, then that can be a condition of unreasonableness, right? It's not fair because the market which you're in, if it's real estate, if it's other markets, then you going by the market rate and you're looking at the market and you're saying this is not reasonable for me. It's not for a conducive for me to even get in that contract, and by this as being so unreasonable and it's not a common practice, then I can try to raise this as a defense on my contract due to how the contract is written and based on the language, and it's causing me to pay 100 times the amount, which is not even fair. So you guys got to learn how to read contracts. And we're talking about what is being reasonable, right? You got to look up this word reasonable because it's not what you really think it is, right? When you understand what the definition of reasonable is, and you look at the reason, right? We got to look at what reason is. So when we're dealing with reasons, we're looking at remedies, right? What is the remedy according to the contract? So a lot of these contracts we're in, right? It may not give you a remedy or an out. It lock you into a contract where you can say this is it's unreasonable because you put me in a contract and you defaulted and you don't even give me a remedy, right? Because a lot of you guys are in contracts that you read, and the contract doesn't allow you to get any recourse when the other party does something what? When they default or do something on their other end of the contract that's dishonorable. And now you can't get recourse that they locking you in and it's a one-sided contract, always favoring them. So you got to be able to look at these contracts and say this is unreasonable condition because I don't have a remedy and they got all the remedies. I hope I'm making sense to everyone, because this is just this a little bit of what you're going to get when we're dealing with contract law. So many of y'all think a trust is the say all be all, but the trust has to contract just like you. Some of y'all scratching y'all heads. It's so many things that you can do dealing with contracts. Once you understand, okay, what kind of trust I want? Do I want a common law business trust? What kind of trust do I need? A legacy trust, a living trust? What kind of trust that you want? There's so many different forms, types of different trusts, but it's going to be based on your understanding, especially dealing in a particular market and based on a particular understanding of how to contract. Because at the end of the day, a trust it's a contract, and a trust can contract many times over, and it can set certain conditions. And then you have a common law trust that the Constitution doesn't require you to get an EIN or a social. So if you know how to contract, you know how to utilize these things to your best of ability to give you leverage and leverage the field, so now you can understand what you can do to protect your assets. Okay,
We'll go to the next screen, King. All right.
So these principles operate alongside legal statutes and doctrines, ensuring that commercial transactions are conducted with integrity and reliability.
King.
Ready. Section 1301.103, construction of Uniform Commercial Code to promote its purposes and policies. Applicability of supplemental principles of law, UCC 1-103. Ohio Revised Code, Title 13, Commercial Transactions, Chapter 1301, General Provisions, effective June 29, 2011. Latest legislation, House Bill 9, 129th General Assembly.
PDF.
Yeah,
Brother
PDF.
King.
Is he out?
I just read that until we.
Construction of Uniform Commercial Code to promote its purposes and policies. Applicability of supplemental principles of law, UCC 1-103. A. Chapters 1301, 1302, 1303, 1304, 1305, 1307, 1308, 1309, and 1310 of the revised code must be liberally construed and applied to promote their underlying purposes and policies, which are, number one, to simplify, clarify, and modernize the law governing commercial transactions. Number two, to permit the continued expansion of commercial practices through custom usage and agreement of the parties. And number three, to make uniform the law among the various jurisdictions.
I give him a call, brother. See what's going on. All right. So those who are just joining us, this is the principles of contract and looking into principle of a contract. So we have Brother King Al Bay as our special guest. Across the screen is my website, mooresandmasonry.org. If you're interested in getting copies of my book, go to my website. I'll be December will have been the 9th anniversary of 9th year anniversary of Moors and Masonry Part 1. It was released in December 2016. So just can't believe it's approaching 9 years after 20 years of research. Wow, definitely. So once again, I'm looking at the construction of Uniform Commercial Code to promote its purposes and policies, applicability of supplemental principles of law, UCC 1-103. Jeff, thank you for joining us today. For this will be uploaded on the Moroccan Post, on the Magnet Crystal Pyramids YouTube page. Magnet's Crystal Pyramid YouTube page is live. We also have of the free recorded core classes and lessons on the Moroccan Post Media YouTube page. So King should be joining us, getting back to us, rejoining us shortly. What's going on, brother?
No answer, bro.
Give him a call. Call him again.
Mm-hmm.
All right. So once again, going across the screen, my website, mooresandmasonry.org. We have, once again, the upcoming contract and trust and contract legal safeguard course. They'll be on Saturdays. I think it's from 2 to 4, 3 to 6. I think it's from 3 to 6, I believe. Can't recall right now. They'll be on Saturday, starting Saturday, May 10th. 12 weeks, a 12-week course. The $299 for the course. And you're getting a taste of it tonight. Some of the points that we're raising. He's not answering?
No answer, bro.
Yeah, call him again. We live and direct with this. All right, so looking at once again, Moroccan Post Media YouTube page. If you're interested in any of the free recorded lessons or Moorish Treaty Protection and Consular Relations course, we have the various. You didn't answer?
Nope.
Ball as well. I want to jump into another lesson, man. Wait. So we have once again that no answer.
Check your message, bro.
I can't. Tell me what he's. I mean, it's emergency.
Yeah, he said he had to take a call. Yeah. Yeah.
I mean, it came across so fast I couldn't. Yeah.
Oh, gosh.
Yeah. He didn't say what time, how long he'll be.
Nope.
We live, bro, man. Well, of course he knows that. Isabel, tell us, talk. Let's talk about so he gets on Wednesday's class.
Oh, you said let me in. Hold on. You said let him in.
But Hank, keep backstage. Peace, brother Hank. I'm about to call Hank then. Hold on.
All right.
Hank, you hear me? I'm about to leave. Come back.
All right. So peace. Yeah. We started Moorish Midwest Educational Network study sessions. We started those. We began those March 5th. So the past Wednesday, the topic of conversation was around territorial sovereignty. It was the application of international law. So looking at everything from the international perspective, the international law applications, which would be territorial sovereignty. You on there, brother?
Oh, they got me in here.
All right, good. All right, so go ahead, King. Reread this slide here, Israel.
All right. So construction of uniform commercial code to promote its purposes and policies. Applicability of supplemental principles of law, UCC 1-103, A, chapters 1301, 1302, 1303, 1304, 1305, 1307, 1308, 1309, and 1310 of the revised code must be liberally construed and applied to promote their underlying purposes and policies, which are, number one, to simplify, clarify, and modernize the law governing commercial transactions. Number two, to permit the continued expansion of commercial practices through custom usage and agreement of the parties. And three, to make uniform the law among the various jurisdictions.
So, what you got to understand when we talking about something that's liberally construed, that means it's not strictly construed. Strictly construed means that it has to be based on strict, specific language. When you liberally construe, guess what they can do? They can reach to other sources, right? Case law, reach to other things, definitely case law where they can try to interpret what this type of relationship was created from to get to create a case law associated based on this particular market or whatever that we're dealing with, like mortgages or something, right? There, go look at a case law similar based on the same application and come up with a legal decision based on the similarities of the case, right? But when you take something that's very strict, right, you strictly construe it. It's got to be very strict in that language. That language is strong. It's not vague. You meet all the necessary things for a common person to interpret and perform the contract to the letter of the law. So we got to understand all of this stuff about contracts. You got a lot of Moors that's teaching things and they don't understand principles. Because when you understand the principle of something, right, you can look into the jurisprudence behind it. It can give you a better, what was the philosophy or the understanding in this principle? Because that's when we're dealing with jurisprudence. You're talking about the philosophy of law. And this is these principles are the building blocks, right, to create the system, right? If you look at a house, right, and it's layered brick by brick, the bricks will be considered the principle and the foundation that holds it up. You will have the foundation, they poured it and made out of rocks or stones or cement, concrete, or whatever it is, right? And then you stack the bricks to create the home, right? Same understanding. The principles is the building blocks to ensure, right, that everything is standing, that you have equality amongst the law. So you guys got to understand how this stuff works in the formation of law and all of the different things when we're talking about application of law, source of law, findings of facts, conclusion of law, right? You need to understand these principles because these principles is it's the building block or the underpinning to understanding how the law should be functioning. And if you don't know this, then you're not a jurist. You can't be a jurist. You're too far from being a jurist. You got to understand this on this axis so that you can navigate the law with a clear understanding.
Well put. Well put. I love when you go and go. I love when you go into that direction. All right. We go to the next slide.
Should talk about the supplemental principles. Did we get that? Okay. What is that?
Oh.
Okay, go ahead. This is what I'm talking about. Yeah, this is it.
Unless displaced by the particular provisions of chapters 1301, 1302, 1303, 1304, 1305, 1307, 1308, 1309, and 1310 of the revised code, the principles of law and equity, including the law merchant and the law relative to capacity to contract, principal and agent, estoppel, fraud, misrepresentation, duress, coercion, mistake, bankruptcy, and other validating or invalidating cause supplement their provisions.
So this is very important. This is very important about understanding commercial contracts. I need y'all to pay attention to the language, the substantive language in this. It's the language in here, right? So it tells you, unless displaced by the particular provision of chapter 1301 to 1310, right? It tells you it has to be displaced. The principle of law and equity, including the law merchant. So it says the principle of law. So what are we talking about? The principles of law, right? Abdullah, help me out with this. Let's break this down for him. The principle of law. You there, Abdullah?
Yeah, I'm here. Yes. Well, you did it. You did it already, King, when you broke down the philosophy, because
Right.
the principles of law are the philosophy of law, which is the jurisprudence, is the building block for the principles of law. And you actually.
I just wanted just to go over findings of facts.
Are you talking about? All right. But so you gave the philosophy. You gave the philosophy. So now you want to give. Now you are finding of facts, conclusion of law, source of law, operational law, application of law.
Right. Right. So
Yeah.
you need to understand this. These are principles, right? So when you use the principles of law, this is how the court makes a lot of their decisions, right? And then we look at equity. Equity, what's equity? Equitable relief, right? We talking about fairness. We're looking at it at the contract. Then it also tells you, right? It says, including the law merchant. You need to know the law merchant dealing with merchandise, right? The law relative to capacity to contract. So a lot of y'all think y'all know the law. And I'm going to tell y'all something y'all don't. You got a lot of gurus out here telling you the contract, right? So a lot of y'all out here trying to do these contracts, right? What if you created an institution that did that spoke for you, that had a power of attorney over everything that you did, and you couldn't do nothing without consent of that trust who has power of attorney, right? Now you can walk into a room or contract or something, right? Let's say you buy a house or a car, and the trust say, unless the trustee consent, right? It has to be a third part to the contract and agree with this, then all contracts that you do is null and void, right? And then you give the other party notice of this, and they have 10 days to respond, right? To verify this, and that the trustee haven't gave consent. If they move forward with the contract, guess what happens? You could be paying on your mortgage, doing all that, and then you default. Guess what they can't do? Because you never had the capacity of the contract to even be approved for that loan. That the trustee had rights over you, your ability to contract. Some of y'all think y'all know this stuff to a degree, and you guys don't understand contract law at the first. Y'all don't know what your rights is, some of your personal rights. Some of you guys, I don't think, I listen to a lot of people, well, you got exclusive equity, exclusive jurisdiction, status correcting, correct your status. And they don't even know the first thing about political legitimacy, international law, and the application associated with that. How we became the inhabitants or subjected to the jurisdiction based on the international application. A lot of us don't understand what this means dealing with contracts, right?
Mm-hmm.
So we need to understand dealing with trust law. A lot of y'all don't understand trust at all. You don't know, like you have a right to safeguard what you do. They're called contractual safeguards, legal safeguards, right? Contractual legal safeguards. So this is where you get your remedies from. You got remedial law, where you understand, hey, if you fail to do this, right? Or if this contract, if this part of this contract is the deemed void, right? The other parts still have, they still can be enforced. That's called a severability clause, where if that part of the contract or certain parts of the contract are being severed, right? But the other parts stay in force, right? Then you have all types of a right to change jurisdiction. All of these different things based on your ability to contract, right? You have the individual sign and do something. Let's say you got a trust in a certain state, and then you have certain things. You create a minimum contact, but you wanted to go back to that jurisdiction, right? It has to be you have.
Ah, he's still on.
Yeah.
Brother King, he's coming back in. All right. It's King. Man, it was it, man. He's on fire, brother. He's on fire. On fire. All right, so you with us? Across the screen is my website, mooresandmasonry.org. We have the upcoming course, Contract and Trust Legal Safeguard course, starting on May. It's going to be on Saturdays, starting on May 10th for 3 hours. Is he a brother King? I mean Hank. Is he backstage? Give him a call, Israel, please. Give All right, yeah. Let me read. Yeah, give me that. Give me that page. Yes, that you just left.
First.
Yeah, that one. Yes. Thank you. Trust and contracts, legal safeguards. Teacher King Albay coming. It's actually this is the old date. We have the new date. That he. Thank you. All right. Yeah, my man. May 10th, 2025. All right, duration 12 weeks. Course outline. Got that shadow there. I mean, I can course outline and overview. The 12-week course provides an in-depth exploration of trust, contracts, and the legal mechanisms that safeguard them. Each week builds upon the first, the last, offering a comprehensive understanding to help navigate and apply these concepts effectively in both personal and professional contexts. All right. Did he answer?
No, I said it's an emergency call.
All right. He was on fire, man.
Yeah.
All right. Yes. These are the dates. Thank you, Israel, for putting this, adding this.
Mm-hmm.
These are the dates: May 10th, May 12th, May 24th, May 31st, June 7th, June 14th, June 21st, June 28th, July 5th, July 12th, July 19th, and July 26th. This is all on Saturdays. So you see here, Saturdays. So I wanted to I actually had to send this to King. And I'm glad, thank you, Israel, for adding this so that people can have the actual dates,
Yep.
So this is good. Is there another slide that we could talk about the course? While he's still, let's just get, I don't know, any other slides about here we go. We'll just talk about this until it comes back. Week 1, you want to read?
Yeah, I would.
All right.
Week 1, Introduction to Trust. Students will learn the fundamentals of trust, including definitions, purposes, and the roles of the settlor, trustee, and beneficiary. This foundational week sets the stage by discussing the legal basis and common uses of trust in estate planning and asset protection. Week 2, Types of Trust and their functions. This week explores different types of trust, such as revocable, irrevocable, living, testamentary, and special needs trusts. Students will understand how each type functions and the responsibilities involved in managing trust assets. Week 3, Benefits and limitations of trust. Students will examine the advantages of using trust, including asset protection, tax considerations, and estate planning benefits. The week also covers the limitations and risks associated with trust and strategies to mitigate them. Week 4, the role of a trust protector. This week introduces the concepts of a trust protector and their importance in trust administration. Students will learn about their duties, powers, and how they can modify trust terms, oversee trustees, and resolve disputes. Week 5, assignors and assignees in contracts. Students will understand the process of assignment in contracts, the legal implications, and the responsibilities of assignors and assignees. The focus is on how rights and obligations are transferred within contractual agreements. Week 6, licensing and rights of publicity, part 1. This week delves into licensing with a focus on the right of publicity, exploring how individuals can control and monetize their image, voice, signature, and other personal attributes. Students will learn about the legal basis of the right of publicity and how to create licensing agreements for personal rights. Week 7, licensing and rights of publicity, part 2. Continuing from week 6, students will learn about protecting and enforcing the right of publicity, including unauthorized use and legal remedies. The week also covers leasing personal rights, considerations in the digital age, and ethical implications. Week 8, power of attorney, POA, forms and uses. Students are introduced to the concept of power of attorney and its various forms, including general, special, durable, and medical POAs. The week emphasizes the importance and practical applications of granting POA in financial management and healthcare decisions. Week 9, legal considerations of power of attorney. Building on the previous week, students will learn about execution requirements, revocation, termination, and safeguards against abuse of POA. The focus is on legal aspects to ensure the principal's interests are protected. Week 10, contracts and safeguard provisions, part 1. Students will explore the essentials of a valid contract, including offer, acceptance, consideration, capacity, and legality. The week also covers common safeguard provisions like indemnification clauses and limitation of liability. Week 11, contracts and safeguard provisions, part 2. Continuing contract studies, students will learn about confidentiality agreements, termination clauses, and dispute resolution mechanisms. The focus is on drafting effective contracts with robust safeguard provisions to mitigate risks. In week 12, constitutional studies with course review and Q&A session, question and answer session. In the final week, students will spend the first hour on constitutional studies, exploring how a national constitution is a national trust. This will provide a broader legal context and understanding of the foundational laws governing these areas.
All right. You want to?
Yeah, there's still some more.
Give him a call. See if he's ready.
Gotcha.
All right. So this is the 12-week course. That's the summary for an overview of all 12 weeks of the upcoming contract and legal safe trust and contractual legal safeguard course, 12-week course coming your way soon, Saturday, May 10th for 12 consecutive Saturdays. No answer? Did he answer, Israel? Oh. The remainder of this session is dedicated to reviving all the concepts learned throughout the course. An interactive Q&A session will allow students. Did he answer?
Hold on, I thought I was talking to you. I had it on mute at first. Nah,
Yeah.
Oh, still on call. Wait, he's on the call.
He's on the call. All right.
Yeah, he said his client or whatnot.
Yeah, he had a situation that he had dealt with. He said he would only be able to be on for an hour. So I just wanted these. So we just read this page here.
All right. The remainder of this session is dedicated to reviewing all the concepts learned throughout the course. An interactive Q&A question and answer session will allow students to clarify any doubts and discuss practical applications. First hour, constitutional studies, how a national constitution is a national trust. The overview of jurisprudence / philosophy of law, legal principles as the foundation to run government. Rule of law and constitutional governance. Rule of law, constitutional governance, and the protection of fundamental rights / individual rights and civil liberties. constitutional clauses affecting contractual obligations, case studies illustrating constitutional influence on trust and contract law course review and Q&A session, comprehensive review of course material recap of key topics from weeks 1 through 11, interactive Q&A session, addressing student questions and clarifications, discussing sharing insights, experiences and practical application course, evaluation providing feedback on the course experience.
Did he text you?
No response.
No. All right. All right. So we want to continue reading. It's the same page.
Yes, the last of that.
That's the last of that. All right.
Back to the.
So we back to the. Wow. Thought he would be on by now. Back on. Right. Going across my screen is the screen is to my website, mooresandmasonry.org. If you're interested in getting into my books, check out the website. Right, so this is where we are. This is where we actually was the next page. Yeah.
He said he's back.
Oh, he's back. Hank. So he's backstage. Brother Hank. All right, I have to get off to call Hank.
All right. Yeah. Once again, the Moorish Midwest Educational Network, every first and third Wednesday of the month from 7 p.m. to 9 p.m. Eastern Standard Time, live on Zoom. The reoccurring Zoom link has been sent out via text message, Facebook, Telegram. Yeah. So come learn principles, legal principles, international principles of law, the application of those international principles.
He be so serious and mad. He like, call Ken.
All right. We have King back. Are you ready, King?
I'm sorry, family. I'm back. So let's talk about these things: errors, omissions, mistakes, defects, and contracts. So what are you looking for when you go through a contract? These are the things that you're looking for.
You thought. Hey, there we go. All right, you good? You back? All right.
Even so, I was just talking. I said when you get a contract, what are you looking for? And even in law, you're looking for errors, omissions, mistakes, and defects. Misappropriation of law, a defect, an error. So when you file an appeal, right, they tell you that it's either abuse of discretion, right, or plain error. Certain things that different forms of abuse. Error in law is failure to provide due process, right? These are errors or abuses that can be identified, errors, defects, right? So what is the defect? Something like due process requires certain things, right? When we're talking about even contracts, right? Because you have clauses in contracts, and you write a contract, right? That's due process. The substantive language in the contract determines how, like let's say you have a contract and you're unable to.
Oh man. All right, so you should be jumping back on. Did he? What's going on? Give him a call. What's going on? Brother Hank, is he backstage? Did he try to get back on?
He said he's back. He texted me, said I'm back.
All right, Hank. He's away from. I gotta call him again. Brother Hank. All right, I gotta jump off.
All right. So once again, supplemental principles in commercial transactions, good faith,
I'm back. I'm sorry, family.
freedom of contract,
It's
pacta
just-
sunt servanda, reasonableness and fair dealings. All right, brother. You got it.
Okay, so talking about contracts and law again, we're going to talk about these supplemental principles because errors, defects, or omissions and defects are supplemental principles in law. Because when you file an appeal, you're looking for errors, right? You're looking for defects, due process. That's a defect, failure to be provided. What's a mistake? You got the wrong name, information, the wrong person, different stuff like that. Certain things that's defective to the case. So you're looking for errors, omissions, right? Mistakes, right? And defects. You're looking for mistake typos and different stuff like that. Something that could, like an order. Let's say the judge wrote an order and he had gave you an order and then the other order wasn't the same. It was a mistake or something that it didn't align with the order that was originally given, because he might gave you, because it might have been a mistake. It could spelled your last name. Let's say they impound your car and they gave you the right first name but the wrong last name, and you didn't check it, and they supposed to release the property to you, but you don't have the right name on the order for the property to be released. That could be a mistake like that. And then we're talking about errors, like I said, and defective processes, like due process. That's a defect in how the court had went about handling the case. And the same thing is in contract. They went about, look, you wrote a contract that was defective because it was too vague. It didn't have enough in there to determine what you're doing. You didn't cite the product. You didn't do certain things to assure performance. So these are defects in contracts that you have to be able to identify. If you don't know what to look for in contract law, stay out of that lane. Or don't know how to look at law. So once you understand these principles, right, you can be able to now, you can navigate through the way the legal system, right? Because you understand something. That makes sense, everyone?
Can you try to move around? Can you in a bad area right now?
Okay, what you want me to do?
Are you right? You fine now. I see TT talking.
So what I'm just telling everyone, right, when we're dealing with law, you have to understand the components, the elements. Like I talk about elements. Me and Abdullah, when we talk about looking at these law, right, things, and we looking at all of these fundamental principles, and we're looking at I'm trying to think, what's the one that we always talk about that sits at the head of the main principle, Abdullah, above the no, it's not equity.
Rule of law.
Rule of law.
All right, rule of law. Yeah, yes.
The rule of law sit at the crown, right? Because it's the rule of law. So when we're talking about supplement, when we read this context, right, we're looking at different principles that's guided by a particular rule. So this is why you got to understand jurisprudence, because you need to know the principles of law, right? Why did that's the first one they talk about. It says, unless displaced by the particular, particular provisions of Chapter 1301, 1310 of the Ohio Revised Code, the principle of law and equity, including, so it talked about that first. So the rule, you got to understand the rule of law. You got to understand the elements of the rule of law. So let's go over some of them elements in the rule of law. Arbitrariness, fairness,
accountability,
accountability,
equality before the law.
equality before the law. It's one more.
You said, no one is before the law. No one is above the fairness. No one's above the law. Just government, open government.
Yeah.
Yeah.
Mm-hmm.
So these are the rules of law. So when we look at due process, right? This mechanism, right? You have to know what the rule of law is because it sits at the crown. It's the crown, right? It sits at the top. And then you have these other principles, supplemental principles associated with the rule of law. Like due process. But they all what? Or birth from the rule of law. And the rule of law is birth from equity. So when we talk about customary law, we talk about the common five legal systems, right? It's customary law, religious law, common law, civil law. What's the fifth one?
The mix of common law and civil law.
A mixed jurisdiction. So you got to understand the type of jurisdiction that you're entering into. This is why the Sixth Amendment protect that right to know the what? Nature in the cause. Why? Because you need to understand the legal system that you're going into, right? So under the civil law, it says there's one form of action that shall be known as a civil action. So a civil action is not a civil jurisdiction. A civil action is not a civil jurisdiction. A common law jurisdiction, right? You got to understand you can have civil actions in both jurisdictions. So you have to know when they ask you if this civil or it's criminal, what is they really asking you when you talk about contempts or different stuff and people asking this about this, is this civil court, is this common law court? So you got to understand the contract that you're in, the jurisdiction that you're under. What is your status related to a statutory jurisdiction? Is that a civil jurisdiction or is that a common law jurisdiction? Right? The prosecutor has to be able to identify what kind of jurisdiction that you're in. And if he failed to identify the nature of that, automatically dismissal because he should know the law. Ignorance of the law is no excuse for no one, right? So they have to identify the jurisdiction. This is what we're talking about, constitutional safeguards. When we talk about the Sixth Amendment, understanding all the elements of the Sixth Amendment to be able to do what? Defeat a claim because it wasn't what? Perfected.
Hey, King, stop for a minute. Go to the Constitution where it says amity, equity, amity, and the common law. That's what you're talking about? The nature of.
Right.
Yeah, just go give them that.
The
Sixth Amendment, and then tie
I don't know
to.
how to do it while I'm on this, right?
Oh no! Just say it. Don't just say it. Just say it.
Constitution, right? It gives you 4 jurisdictions. It gives you common law, right? It never says anything about civil law. It gives you equity, it gives you maritime, and what?
Admiralty,
right? Those are the 4 constitutional jurisdictions that it identifies. It doesn't even talk about civil jurisdiction. So I want you to understand civil actions are not civil jurisdiction, right? So United States is a mixed system. Is the statutory law even constitutional? Because it's not identified in the Constitution. Can you challenge the statute based on the constitutionality that that the statute, the civil law jurisdiction is not identified in the Constitution? It's not with specificity,
Excellent
right?
point. Excellent point.
Right. So when you read the jurisdiction, it says in law and equity. It doesn't say civil law. It says in law and jeopardy, in equity. So what you got to go to the historical context, right? Historical context of what was
It would
English.
be
It's the
common
common law of
law.
English.
Yeah, it would be common law. Yeah, you have to
So
go by
when
that.
of course there was the Supreme Court before they do what? Sit down. They say we shall keep the common law of England. So even even can we challenge the statutory nature of the statute, because I don't even think it's granted by the Constitution.
Excellent point. Oh, that's why I said I want you to, elaborate on that.
Right? So now when they hit you with a statute, what is that? That's a defect in law, because it doesn't what? It doesn't afford you due process. You challenge it on a constitutional question. Now, this is why they got the UCCs. I think they try to usurp that by the UCCs, right? Saying that all crimes are commercial. Why did they say that? All crimes are commercial, right? So they can try to utilize the UCCs and associated. This is why they have what? The two jurisdictions. They have interstate commerce. When you do some type, that's why I say it's all crimes are commercials, and you have two types of commerce, interstate and intrastate commerce. So when you understand these things, you can do what? You know how to break this down and have a legal argument. Now you become a jurist. Now you know what to do and break this stuff down and look at it from a jurist perspective, understanding the principles associated. So when you look at the Supreme Court, stare decisis, res judicata, those are common law principles. They're not civil law principles. The civil law principles are incorporated in the statute. But when the Supreme Court make a decision, they use common law. Is that an error in law? Because they're using a mixed system that's not identifiable in the Constitution? It don't say anything about a mixed system of law. Utilizing the civil law and the common law. It doesn't say that. It got 4 jurisdictions, but all of those should be under the common law. This is what we talking about, being a real jurist and understand how to identify legal questions, constitutional challenges, dealing with defects, errors, and omissions in law, understanding due process, understanding the rule of law. I hope I get this through to my family tonight. What do you think, Abdullah?
You're on fire, brother. You're on fire. I'm going to look at this section and I'm gonna write it out. I'll look over this section. I'll write it out and I'll send it to you. All right. Okay. And then we'll send it out and then we'll put it on the I'll send it to you for review, and then Israel put it on our PowerPoint.
Okay.
That 5 minutes you just said, the 5 or 10 minutes that you just finished up, we're gonna actually write it out. All right, and put it on PowerPoint. We'll send it to you for review. Put it on PowerPoint so people can actually see it, because it's very important.
So we got to understand. First of all, you got to know the legal system that you're in. You got to understand the legal system. Then this is how you a jurist, because you got to understand the principles in which they're using is based on a certain philosophy of law dealing with jurisprudence. And if you don't know these things, how could you make a legal defense? Right? You got to know the legal system to understand the principles being used, to understand what type of legal system that you're arguing.
Give them the legal system again, because the reason I'm saying give it to them again, because of the condition, because it hasn't been properly taught, the millions of people, that includes Europeans, millions of people, that's conscious Moors, unconscious Moors, and Europeans, associate the term legal system with court. They don't associate the term legal system with common law legal system, civil law legal system, religious laws legal system, customary law legal system, common and mixed legal system. They don't associate. They associate it with court. Court is a component. Court is not a legal system. Court is a component of a legal system. Religious legal systems have courts. Common law legal systems have courts. Civil law legal systems have courts. Customary law legal systems have courts. Mixed legal systems have courts. So the term legal system is not to be associated with court. It be associated with the 5 major legal systems in the world: common law legal system, religious law legal system, customary law legal system, civil law legal system, and mixed law legal system, mixture of common law and legal system, and common law and civil law.
So let's
So I just
further, right?
please do.
So when we looking at that Constitution, right? First, you got to look at the constitutional minutes, because it's going to identify what kind of Constitution they wrote, right? And then we got to go back in history, right, and look at what kind of system that country was using, so that we can do what? Have the material evidence to challenge that, right? This is what real jurists do, right? This is how you really challenge, if you're talking about what kind of system that we in, right? What kind of system? Because if you're not identifying to the people, that if it's a customary, common law, religious, or mixed, they need to know. How can they prompt a legal defense and we don't even know the jurisdiction that we in? We don't understand the system of law that's being used against us. This is what when you move up the ladder and you understand law to a jurist, as a jurist do, you look for those things. These are elements in law, right? This is how you come up with a conclusion of fact and a conclusion of law, right? You can look at things. I could ask Abdullah, okay, Abdullah, what the United States, when they came up, what kind of system was they using based on the particular things that we was talking about, the historical points and the constitutional minutes? Could you go into that a little bit, Abdullah?
Well, you actually alluded to that when you referred to the historical context. All right, as jurists would do, is that they will look at the history. So you mentioned the constitutional. So let me just camel back. The constitutional minutes, and even before the constitutional minutes, who they were tied to? England.
Right.
They were tied to England. So we go further back to, there been, we go to the colonies. So I got you. So we go to the colonies. All right. We go to the charters. We go to the colony charters. Or then we go to England. We go to England. All right. And look at that legal system in England. Then we go to the colony charters. Because the colony charters are set up based on the common law legal system of England. Charters are granted. Yeah, well, so because the king is talking about thinking like a jurist. We talking about thinking like a jurist. So we're going back and we're going further back and we're going further back. All right. So we have the county charters, right? And so go there. Then you have the state constitutions. The state constitution is 1776. 1777, the 13 original states and things like that. So you're talking about going further back, and yes, go to the Articles of Confederation. Things like so. That's what a jurist does. Now, we're not talking about law school. Hear me out. We're not talking about attorneys that y'all know. We're not talking about attorneys that y'all see. We're not talking about the people that you meet. We're not talking about them. You don't know these guys. You don't know these people. You don't know these people. You don't meet them. Y'all don't meet jurists. Y'all don't meet jurists in the courtroom. Y'all don't meet jurists. They're not prosecutors. Y'all don't meet them. All right. So those not people that y'all went to school with. Y'all, we're talking about jurists, not attorneys. We're not talking about law school. What I'm doing, King, is going to what they're familiar with. They're only familiar with attorneys. They're not familiar with jurists. They're only familiar with law school. They're not familiar with JD level. The general public do not know that. We're talking JD level. We're talking jurist level. We're not talking law school level. So I just want to be very clear. So I want to hood it. I want to hood it. I want to bring it down. All right. This is what. So you meet. I'm going to meet where I want to meet the people where they are. Where they are is law school level. Where they are is knowing attorney levels. They don't know jurists. You're not going to have attorneys say, "Oh yeah, just go back to England, and yeah, go back to the Constitution, go back to the charters." They're not thinking, right? Then that's not what they're not even taught to think that. That's not even part of their thinking. So you're not going to meet attorneys that think like this. This is a thinking that's taught. It's philosophy. It's philosophical thinking. King, I want you to talk the difference between processes and philosophy of law. Philosophy of law versus processes.
Okay, when you understand as a jurist, right, a lot of people they create a lot of these processes like status correction. It's not a principle of law. It's not based on somebody created an idea that they believed, right, a systematic thing in which may have worked at some point, right? And they create a process, right? This process in which has no legal basis in law because they're not a jurist. And they can't identify, right? A jurist, he's guided by the principles because he understands the structure and the system, the legal system in which is being used. So when he walks there, he can identify and talk to the judge based on the principles of law that is being used. When you talk about these legal processes, you get in there and start talking about all of these different things and these misconceptions that don't work because you think you figured out a systematic way of doing something that you created, but it doesn't really have a strong basis in law.
All right. Good point.
Jurists use principles. And then you got other individuals that use a process. And this is a legal process. No, if I'm going to use something, it's going to be based on legal principles, sound legal principles that can be identified based on the elements that created that principle. Because I know if the court used a principle, the elements that's created. So when we talk about the principle, right? and we talk about the elements, I want you to think about this, how your genetic makeup is, right? You are the principle, but you are made up of different elements called DNA, right? So the principle is made up of these elements. And if the court rule using a particular principle, those that DNA must be present to identify that principle. Because that principle, right, just like you, right, you the principal, if your DNA is not at the crime scene, they trying to say it was you and they collect DNA that's not yours. What? They have to rule you out. Same process of thinking. When they use a particular court, Supreme Court, or a court use a particular principle, you must know those elements to say, no, all the principles is not there. So this is an error in law. Did that make sense, family? Abdullah?
Yes. You have some time to fill a couple questions, King?
Yeah, I can do about 2 or 3 questions, then I gotta go.
All right, no problem. We'll end it with that. So we let Israel check out. Is there any questions? All right, type your questions in. We're going to do 3 questions and we'll end. 3 questions.
Did I do a good job tonight, fellas?
Man, you knocked it out the park, brother. You did a Hank Aaron, brother.
Thank you.
You did a Hank Aaron. I ain't gonna say no Babe Ruth. Hell no. Hell no. I ain't never gonna say that. Hank Aaron.
What you think, brother Israel?
Yeah, he was on point, brother. Yeah.
I know a lot of Moors and a lot of people haven't heard.
Hey, they need to, bro. You gotta bring it, bang. That's why I said you gotta bring it. You gotta bring it, brother. We need this. We need this. We need this level. We need the philosophy. We need the philosophy level. We need the philosophical level. Because it's the thinking. Epistemology, a branch of philosophy of how one knows law. Of how one knows knowledge. A systematic way of thinking.
Right.
Jurisprudence is a philosophical way of thinking about law, not mere processes. Conscious Moors don't have this. They need the philosophical thinking.
Yeah, you got to. So that's why a lot of people, I tell them, when I was out there doing my stuff, I was tough. I was real tough. I was like a Ford truck.
All right, so we're gonna take those 3 questions. You got a question, Israel?
I don't see any questions on here other than can one still get into that course?
Yes. The course starts so May 10th. The course starts May 10th. We have the 12. We gave you the 12 consecutive Saturdays. Yes. The link will be on we'll put on my Abdullah Bey's Facebook page, Israel's Facebook page, the Moroccan. We'll put it on where we can we put the link in the chat or no? Is it too big to put in the chat, Israel? The Eventbrite link.
Yeah, I tried to put another link in there. It wouldn't let me post it.
It wouldn't let you put the Eventbrite link in the chat. Yes. You can go to my Facebook page, Abdullah Bey. I'll put it up as soon as we get I'll repost it on my Facebook page as well as on the various Telegram pages.
Yeah, family, you gotta come to this.
Yes. You can still. The course is still open for registration.
You ain't gonna see nothing like it. Like tonight, you ain't heard nothing like.
No, they haven't, because they haven't heard the philosophical way of thinking about law. No. So of course they haven't.
So now think about this course. Ooh, the course is gonna be fire. Y'all don't even understand the course will be fire. You talking about trust law? We can get into different trusts, and I'm gonna make it simple. I don't want to. There's so many different trusts that you can use, right? But we need to simplify this. Kiss it. We want to kiss it. Keep it simple, stupid, right? We want to kiss it. Why do we want to kiss it? So people can grasp the idea of what they're trying to do. Just you can have 100-page trust and you don't even understand what the trust do. You don't understand what it is. You just say, I got a trust. I'm gonna put my car in the trust. But you ain't got no legal safeguards. You trust and creating LLCs, you all in the mix and you all in trouble. You didn't still gave away your rights because you didn't got no you ain't safeguard. A lot of y'all think, man, public and private. You hear this public and private, public and private, public and private. All they talking about is personal rights of the government and then personal rights of you. You have a lot of personal rights, right? You have the right to contract, freedom of contract. I can pay you in rocks and stones. I don't have to use Federal Reserve notes. I can pay you in gold and silver. I don't have to, that'll violate a fundamental right. With a private right dealing with personal rights. Private rights is your personal right. Me and you have the personal right to do things in accordance, right? So when we talk about this civil law, right, when we talking about that the federal law and all of these things, we got to understand how did these things exist? Is any of this stuff constitutional? This is why they talk about the taxes. You can't even find what? Nothing to tell you to pay a tax. Because these they don't use the word pay. They use other methodology of words that could be vague or misinterpreted. This is why you got to understand the source of law. So when they say this word, right, pay or whatever, you can say, what source are you using? Identify the source of law. What's the source of law you're using, please? Is it a federal, state statute? Is it civil? I'm trying to figure out where are you coming from? Because the Constitution only identifies 4 jurisdictions. So I need to know the source of law. Please identify the source of law when you're saying certain terms and words. Right? So people ain't hearing it from this level of understanding. When you understand how the law operates, you think totally different. Right? I don't have processes. I understand I'm a jurist. I understand how.
Yeah, they don't. They haven't. They've heard for the philosophical level. No, they haven't, because it has been. Yeah.
Right. So, me and Abdullah, man, I thank you again, brother. You don't know how sharp you made me, brother. I tell you, they don't know. Brother, you done made me so sharp. Teaching me international law. Oh my God.
Yeah, that's my thing, man.
I
I love international law, man. Whew, I love it. I love it, man.
now I understand, and now I know how the functionality of this stuff works. Come on, man.
I love it, brother.
Brother Israel, we on fire, brother.
Yeah, we hot, man. Yeah.
Like Stetsasonic on fire. On fire against the rock.
You ain't. I'm just saying the dynamics of this of what we do in the Midwest, right? Going to the Moorish Investigative Committee and going to the Moroccan Post, you guys are getting substance that you haven't seen in the Moorish movement ever. Never.
No, because they dealt with process. They don't deal with the philosophy, the philosophical understanding of law. They have. That's not. Oh, hell no.
Not at all.
So a lot of I got the status correction. Okay, what's the status?
Them understand what's philosophy, so they can't think proper.
Right.
They can't think philosophically. Let me use they can't think. They can't think philosophically.
Right. So, no, man, I got to get up out of here. I got a lot of work to do.
Brother, thank you, brother. I know you had, situation occurred. But I thank you, brother. You gave us a great time. I know you had to take a couple calls, but it's all good. It turned out to be an excellent class, brother. You laid down some great points and also helped market the upcoming contract on legal safe trust and legal safeguard course. All right. So I know you got to go. All right. So Israel and I will close out. Thank you.
Thank you.
All right. So thank you again. I have Dr. Next week's guest is Dr. Powerton. He will be doing a book review on the Masonic Compass Square and the connection to measurement and timekeeping. Yours truly, the author. All right. So Dr. Powerton will be doing a book review on my book, The Masonic Compass Square and the Connection to Measurement and Timekeeping. Dr. Powerton is a Mason. So a book review will be done by a Mason on next Monday, March 17th at 7 p.m. Eastern Standard Time. So check out Dr. Powerton, a book review on my book, The Masonic Compass Square and the Connection to Measurement and Timekeeping. He's a Mason, and he wanted to do that. So he purchased my book about 2 months ago. So he's actually printed a couple reviews on the book on his Facebook page, and I shared it. But he'll be doing the full presentation on the book review on my book. All right. So next time, Sister Luisa Flores, she's been rescheduled to March 24th in 2 weeks. So we have Sister Luisa Flores. She was one of the keynote speakers of the May 18th, 2024 Moorish Political Unity Conference, and her presentation is that she's a conduit of Moorish nationality, Moorish history, and Moorish political unity education. And we've already started marketing the rescheduling. It is posted on my Facebook page, Israel's Facebook page, and we'll continue to push that. But that has been rescheduled. She will be live and direct in 2 weeks. And so I have March 7th. That's right. The 17th. The 24th, Sister Luisa Flores, and the 31st would be Sister Itiola. Sister Itiola, I've known for since 1998. Since 1998, she's a raw food. She has a restaurant here in Philadelphia, and she deals with raw food. I've known Sister Itiola since September 1998. She's one of the vendors at the Pan-African Studies Community Education Program at Temple University, and we would have a marketplace where vendors would be set up at Anderson Hall, the Temple University campus, and she actually sold the raw food, and the teachers like myself had a stipend. But I met her as a student. I began my etymology studies in September 1998 at Temple University Pan-African Studies Community Education Program. She will be with us on the 31st. All right. Once again, Brother Hank, I greatly appreciate you, brother. I salute you for this platform. This is my 15th month on this platform. My plan is to have at least 30 different speakers for this entire, at least 30 different speakers during the course of the year. All right. Well, about unity, about facilitating unity. All right. So I've already had about 7 different speakers. Your King. Of course, I've had Louisa, Cosmo L, Cosmo L, King. Who else been other speakers? Who else?
Elkanah.
Elkanah, that's 3. I got Louisa scheduled. That'd be a 4. Atiola would be 5. You be 6. Who else have had on since January?
You had a sister on there. I think she was a teacher or something.
Anitra, she was in January. I thought she was. Sister Anitra. So I've already had about 7 already, and I'll say my plan is to have at least 30 of them by December. At least 30 different speakers. All right. I'm very serious about reaching out to others. Very serious about facilitating unity. All right, connection and networking. All right. Thank you again. I appreciate you. Until next week, once again, go to my website, mooresandmasonry.org, for my books. Peace, everyone.
Peace.
Say often, yes, I am
supreme shield of protection surrounding me. Yes, I am. Yes, I am remembering all I was born to do. Yes, I am. Take hold of your crystal, which will magnify your I am affirmations at least 600%.